You're listening to the Voice of Russia in London with me, Juliet. Why would wealthy women want a divorce in an English court? For the last decade, London has been viewed as the divorce capital of the world, but that could soon change and put an end to the so-called divorce tourists. New proposals by the Law Commission for England and Wales say assets should be divided up according to a formula. The proposals could, and I will add are still being consulted, put an end to the long-standing presumption that former wives or husbands should share the proceeds of their marriage equally. Instead, divorcing couples could be allowed to keep all the property and money they owned before the marriage themselves and out of the divorce settlement. Joining me to discuss the new proposals by the Law Commission for England and Wales is Jeremy Levison, a founder of the International Academy of Matrimonial Lawyers, Levison Meltzer Pigott, Gavin Scott, Solicitor at Stowe Family Law LLP, and on the telephone, Tony Roe, the principal lawyer from Tony Roe Solicitors, and Suzy Miller, a divorce planner and inventor of the world's first Divorce in a Box, a stay-out-of-court style travel guide for divorce. First of all, my question to the panel is why, if so, is London the divorce capital of the world? And is it time to change the law to limit the settlements made in court? Gavin Scott, I'll start with you. London is perceived by some to be the divorce capital of the world. Why would you think that?
Well, I must say that I am quite indifferent on this. I do see a lot of clients coming from abroad who live here, who spend most of their time in both England and their own country where they're living. There's connections here. And I can see there's a lot of jurisdiction issues, a lot of foreign clients using this jurisdiction to petition for divorce. And I can see why, because other countries, this country in England does provide some good financial provision for wives and husbands, and it's more favourable to them to petition here. So I can see why it's used.
Some might say that actually the divorce courts in London favour women more than men. Would you agree, Jeremy?
We're supposed to operate on a system of sex equality, and certainly we operate on a system of fairness. That said, it's my view, and I suspect a generally held view, that if you take the same set of facts as between a husband and wife on the one hand, and reverse exactly the same set of facts as between wife and husband, then the wife will come out more favourably than the husband were the roles completely reversed. So yes, I would agree with that.
Would you agree that London is the divorce capital of the world?
I think from time to time it's been the divorce capital of the world, but our law shifts in and out and it goes up and down, and we work on a 1973 set of principles which says do what is fair. And sometimes what is fair in London is more fair than New York or Paris or Hong Kong. But at the moment, I don't think that is the case. I think we reached the top of women's, if you like, normally wives' fairness about 7, 8, 9 years ago, since when the judges realised that they were being too fair, and we've pulled back. And I think that our law at the moment is coming into line with a lot of other jurisdictions. And what you mustn't forget, is that you have to live here, basically, to acquire the jurisdiction of an English court. So you can't just turn up with a suitcase, go off to your divorce lawyer and start to take divorce proceedings against your American husband on the next day. It doesn't work like that.
Tony Roe, could you just outline what these proposals are?
They're not a change in the law, first of all. The thing is, this paper, the Matrimonial Property Needs and Agreements Consultation Paper, follows quite hard on the heels of the original work done by the Law Commission, which closed in April last year, on qualifying matrimonial agreements, prenups, premarital agreements, postmarital agreements, which it's begun to filter the information about within this new paper. What the Law Commissioner says is that those qualifying agreements, prenups or whatever, as long as they cater for needs, may actually be effectively enforceable within any new framework, but it still has to conclude all its investigations, which is not going to happen until autumn 2013. Of course, the question is, when you're dealing with this kind of area, you have to know what you mean by needs, and that's not something which is particularly clear, and you have to look at what you mean by non-matrimonial property. And the paper seeks to look at any principal changes in what it calls spousal support or needs, whether it be maintenance or capital provision, it recognises that that's going to be a long-term project which would need further research and so on. But in the meantime, it looks at what could be done, because don't forget, even on Ministry of Justice figures, we've got about 210,000 people falling out of the legal aid system pretty soon. And how are they going to get access to justice or knowledge and information if they're not going to get legal aid and they can't afford a lawyer?
Thanks, Tony.
So
Before we come back to the questions on legal aid, I just want to bring in Suzy Miller, the divorce planner.
Going back to being seen as the divorce capital of the world, I think even in our own country, there is a perception that where there's money and property involved, that divorce is almost inevitably adversarial and that it involves going to court. And this is the core issue for me. And the whole work that I've been doing, collaborating with the Ministry of Justice and helping promote mediation and trying to let people understand through Divorce in a Box that there is such a thing as a collaborative lawyer where you don't go to court, which is something that most people have no idea about. This, I believe you've really got to educate people themselves so that they know what choices they have available, and that their best option is not to rely on the law system, the legal system. They do need more clarity in how everything works, but really we need them to be deciding things with financial planners, with collaborative lawyers and mediators, and not going to court at all.
The problem with mediation is that it kicks in at a time when emotions are running high, when the English model of mediation is that you have two clients and they go and sit in with a mediator. One feels much weaker than the other. In my experience, mediation works, but only for a very small percentage of cases. Collaborative law, I'll keep my views to myself.
Can I just deal with the go-to-court concept? I think it's crucial to understand that any agreement or settlement arrived at between a couple is approved by a court, so that there's no comeback further on down the line, so somebody doesn't make a further application against capital they acquire after they thought they'd settled everything. So going to court is imperative from the point of view of having any agreement or settlement approved by a court. That still involves discretion in the same way that a ding-dong battle would do, a fully contested hearing. But there are lots of ways of trying to get to resolution. Yes, it can be a full-blown battle, unfortunately. The thing is, most matters do not go to a fully contested hearing, even if an application is issued. Mediation, collaborative law, and arbitration, and I'm an arbitrator and my firm deals with collaborative law and mediation, they're all tools in the box. They're not right for necessarily everyone, but they can actually be good ways of solving these issues.
Wellbeing experts, life coaches, are these all going to help the mediation, Gavin?
Well, going back to the mediation point, I think that there are clients out there who are going to benefit from the mediation. There are other clients who won't be in a position to mediate yet, perhaps because the breakup's fresh, perhaps because there's maybe domestic violence or other issues why it would be inappropriate. But there certainly are clients out there who will benefit from mediation and the benefits of that process in terms of cost and time.
You're listening to The Voice of Russia with me, Juliet Spare, and we're talking about divorce. Should the laws in England and Wales change? Joining me is Jeremy Levison, founder of the International Academy of Matrimonial Lawyers, Levison Meltzer Pigott, Gavin Scott, solicitor at Stowe Family Law LLP, and on the telephone, Tony Roe, principal from Tony Roe Solicitors, and Suzy Miller, a divorce planner and inventor of Divorce in a Box.
I've been collaborating with Divorce in a Box in New York with mediator Ken Newman, and he's very keen to, he often uses usually ex-judges who work as arbitrators, and he finds that if they get really stuck, but otherwise the mediation's been great, quite often it's a relief to the couple if he says, will you let this person decide for you? It still at least is a decision on their part to let someone else take that, perhaps just too difficult for them to make that particular decision themselves. So I think it's a really important addition and would really make a difference. However, you still need to encourage people. I think mediators and collaborative lawyers need to do even more, which they're doing quite well actually at the moment, to encourage their clients to really prepare before they go into the process. And that involves a lot more linking up of different professionals with different skills and collaborating and working together.
This amendment and consultation period on the Law Commission for England and Wales, and suggesting that perhaps in the future prenuptial agreements will have more gravitas. They are yet not enshrined in the law, and that property acquired prior to marriage would not be necessarily included in the settlement. Now, would you agree that this is a correct passage to go down, Gavin?
It's going to be interesting. I mean, the Law Commission report looks at prenuptial agreements and matrimonial assets, non-matrimonial assets and property they had before the marriage, and how that's going to be examined in the marriage. You know, what happens if the property's sold and then purchased another property? What if it's the matrimonial home or the contributions going to the matrimonial home? So it will be interesting to see what the views of other people are on the Commission's suggestions there and ideas.
Jeremy, do you think that there is this necessary amendment and change, or do you think, obviously, going back to the question, is should the law courts in England and Wales adopt and change and take on board prenuptial agreements or not necessarily split assets 50-50?
It's a very broad question. The report itself says that it's not a full review of the area of the law. It says that its remit is very, very limited. It states on page 29 of my copy that says where there is widespread dissatisfaction with outcomes is unclear. In other words, nobody knows even if there is a problem that we've got to consider. And it then says, I think interestingly on page 92, in connection with this, should there be more certainty? I think this is an interesting passage. Rules will generate answers that are unfair, but so may discretion. Discretion is expensive, but the application of the rules may be disastrous to an individual, as may discretion.
Well, why is this consultation period taking place?
Well, you may ask. My own view is, look at prenups. I mean, Gavin's just been talking about prenups and the Law Commission report. The Law Commission is going to have spent hundreds, thousands of hours, at heaven knows what expense, looking into that question. The judges have already got there. We had the famous 2010 case, Granatino and Radmacher, and the judges basically say, yes, we're going to leave prenups, or going to give effect to prenuptial contracts and hold them to be valid and binding unless there's some spectacularly unfair reason as to why we shouldn't do so. And that's what the Law Commission is going to say, and I think the same will happen here. The judges are already getting to a system which is envisaged by the law. Our present law is pretty much, takes all this into account and keeps Section 25 of our Matrimonial Causes Act in effect, which at the bottom of the line says if something is unfair, then we can tinker with it. The problem with rules and formulae is they don't work.
Well, why are we tinkering with, obviously, what's currently in place? Tony Roe.
I think I don't think it's right to say that the Law Commission is spending hundreds and thousands of pounds or whatever on this exercise in its own right. This is something which the government actually asked it to look at following its response to the Family Justice Review. More to the point, as Jeremy will know, a number of leading judges have greeted with a good deal of happiness and hope the Law Commission looking at these sorts of aspects. And one leading commentator, and it's mentioned in the report, talks about judges really being faced with the task of a bus driver, given loads of instructions, told how to turn left and right, but not know where they're supposed to be going, not know what their destination is going to be, apart from the fact it's reasonable. So, we do have a system which is a society which is very different from the late 60s when the law was last reformed, which culminated in the 1973 Matrimonial Causes Act. And I think that's got to be borne in mind. And this consultation is a golden opportunity for everybody, including Jeremy and everybody around this table, really, to look at and consider and input what they feel should be done.
A golden opportunity. You, Suzy Miller, you're already halfway there in that you do a divorce in a box, the world's first stay out of court travel guide. And I wondered whether this movement towards sort of mediation is right up your street.
Well, it's very much what made me create the box, which is a real box, by the way. Ribbon is optional. And it was to get the key information of simply what mediation is. A lot of people think it's about getting back together. They've never heard of collaborative law, and they just really don't have any sense of the choices, and that they are in charge of their divorce, not the lawyers, and they need to understand the roles that everyone has and how those roles are important, but there's a time and a place for when you need those specialists. So by packaging it in a way that's nice, basically, it just means that people at a very early stage who are full of fear, might be too scared at that point to even talk to a lawyer, can investigate and get an idea, and in some cases then won't get divorced at all, because actually it's a horrible process. And again, people are often unaware how awful it is emotionally and psychologically. And also, if they do end up fighting it out in court, how that can be incredibly destructive, not only to their children, but for to them, and many people become very bitter and very upset and angry for many years to come. So I'm coming at it very much from wanting to empower the people on the ground, and I do see that certainly with the lawyers I've talked to, there seems to be a lot of variety on depending which court you're in and which judge. They've actually said to me, look, you might as well toss a coin sometimes as to know how this is going to come out. So at least with mediation and the collaborative process, all the round table discussions that seem to be evolving out of the effects of the collaborative process, people get some sense of control over what they want to decide to happen. But they do need a lot of often psychological and emotional support to do that.
Would you then agree that there needs to be a formula for judges to follow in divorce cases?
I feel they definitely do need to have some. I think it's brilliant to have a review, and it is a golden opportunity to have all these discussions, and that there is a need to have more clarity. I absolutely agree also that if you can't put things into tight little boxes and say this is what you do on this occasion, the judges need to be able to have a certain amount of leeway, but there definitely does need, from my experience, to be a better, clearer framework, especially for people who are then going to be the increasing number of people who are going to be doing it for themselves, because they won't be able to get legal aid and they won't be able to afford to have a lawyer carry the whole thing forwards for them.
Tony Roe, you mentioned legal aid earlier. This is perhaps an appropriate time to return to that. Would people who can't afford to go to court or can't afford a lawyer, is it right that they should be able to go online and calculate what assets they're entitled to on a calculator online?
That's not what is proposed by the paper. A formula is one possibility that the Law Commission is looking at, or is asking people to consider in relation to any substantive principled reform, which may take a long time to run. What it does look at needs, from the point of view of information now, consulting. What can you get hold of? The paper floats the possibility that the Family Justice Council, which is an independent body sponsored by the Judicial Office, might provide practice guidance after consultation. And the government itself has talked about a divorce hub, and we haven't really seen what that will be yet, so that there's information there for people who cannot otherwise get access to justice because they won't get legal aid.
You're listening to The Voice of Russia with me, Juliet. Joining me in the studio is Gavin Scott, solicitor at Stowe Family Law LLP, and on the telephone, Tony Roe, principal from Tony Roe Solicitors, Suzy Miller, a divorce planner and inventor of Divorce in a Box, a stay-out-of-court style travel guide for divorce, and Jeremy Levison, founder of the International Academy of Matrimonial Lawyers, Levison Meltzer Pigott. Gavin Scott.
The purpose of this report is to look at, and they've mentioned a formula, but I really do think that, yes, we could have some principles to make the law too easy to understand, but I think there's a danger with being too formulaic, considering that every case is different. Every case is on its own circumstances, and I think perhaps a formula may be very difficult to put in place that would match all, especially for litigants in person.
For what, sorry?
For litigants without people without representation. Our law is very unique. It's the court's a discretionary approach here, and I think that's very important. It makes us unique here.
Makes us unique. So we sort of go back to sort of London being unique in the world in terms of its courts, but making the law easier to understand. Is that bad for business for lawyers? Jeremy?
Let me quote the German example to you. German, with characteristic efficiency, has attempted to codify its law within the German Civil Code, and they have rules and formulae for everything. What then happens is, oops, doesn't work. One size doesn't fit all, and so we have exceptions to the rules. Fine. And then they find, oops, those exceptions don't work either, so we have exceptions to the exceptions. And in the end, the Germans have given up, and they work on their basic civil code, which, if you like, is the equivalent of our Matrimonial Causes Act, and they now say, yes, we've got to send it to the judges to deal with cases on an individual basis. So you can try and impose formulae on the system, it won't work. And if you start getting me onto the Child Support Act, which has tried to impose rules and formulae on child support, and whether that has had any effect in making life easier or solving problems, we'll need another half an hour. And every country that tries to, what I was trying to say is every country that tries to adopt a formulaic approach finds themselves having to deal with cases on a case-by-case basis. And so I don't think we'll be any different. One size simply doesn't fit all.
So implementing any type of formula under these proposals or after this consultation would be pointless?
It might work in many instances, but there's going to be so many exceptions, as has happened with the Child Support Act and the injustices that has thrown up, that you'll still have to look at them on a case-by-case basis to see whether the formula is appropriate. So it will help some people, but it won't solve the problem.
Suzy Miller, would it mean that perhaps you'll see an increase in clients because it'll be people that would choose to sort of seek an alternative way of getting divorced? And why do people go to you in the first place anyway?
Well, just to clarify, what I do is provide them with the information and resource in the form of the box and point them in the direction of financial planners, mediators and collaborative lawyers, and give them encourage them to go and speak to them and to find out how that works. What I'm really doing is giving them a wider area of choice. But the issue is if there are going to be more people trying to do it themselves. So it's the total sense of confusion and not understanding how things work that is the real problem for people on the ground. And I do agree that formulas can be very, very restrictive, and that's not going to be a good thing. But I heard the word principles used there. Having clear principles laid down. If the judges are calling for that, then that's something that should be provided. But there just does seem to be so much, I would say, chaos. I know barristers, mediators who've said to me, the family law system is a mess, I quote. So it clearly needs something sorting out, but not to become rigid and tied, because every single divorce and family breakup is unique. So it's a tricky one, but they're having some strong principles and guidelines there, and education for the judges. I know also that I've heard that some family law judges haven't perhaps had necessarily a huge amount of experience or a deep understanding of the complexity of what they're being thrown into, and there's been calls for them to be allowed more training and more time. I think there's just work on the infrastructure to be done.
If you could make one fundamental proposal for the consultation, what would it be? It's
been very provocative. It's raised a lot of issues in my own mind, and I think the likes of everyone around this metaphorical table. What I would say is that I think we're beginning to see an attempt or a proposed attempt to define non-matrimonial property, which I think can be a big issue, whether it's a second marriage, whether it's an inheritance. And what I would say, just to clarify something said earlier, non-matrimonial property isn't sacrosanct under one of the provisional proposals. It may be, if it's not required to meet the needs of the other party, and that's a fundamental point.
But that's the law. Meanwhile,
resolution.org.uk is doing quite a lot of work on different forms of dispute resolution, and you can get a list on there of collaborative lawyers and so on.
Jeremy, then explain what the law is at the moment in terms of matrimonial property. If it's the same, then why the consultation?
Basically, we're also talking at the sort of outside edges here of a few cases. But matrimonial property at the moment, the law basically says you split the matrimonial property, however you choose to define it, and you leave out of the splitting exercise non-matrimonial property unless it's needed. And for example, you take a case where there's £1 million, all inherited by a husband before he was married to his wife. And 10 years later, they get divorced, and there's still that same £1 million, and there's a couple of kids. Well, under a formulaic approach, which would leave out all non-matrimonial property, i.e. property that the £1 million he'd inherited before the marriage, she's left whistling for it. She gets nothing. And so one would say, well, actually, she needs money to provide a home for herself and the children, so the matrimonial property would be invaded to that extent. My own view is that there are ways of squaring that circle. In other words, perhaps even providing her a lifetime's use of non-matrimonial property. There are other ways of dealing with this, but to come up with a formula that says non-matrimonial property, you don't get a penny, sometimes is simply not going to be fair, particularly where children are involved.
As a mother of three, if that were the case, then I would not get married again. I would live with someone with a living together, a partnership agreement of some kind. I don't know how much legal enforcement I may have with that, but it would put me off actually getting married to someone because particularly, I think a new mother would be more of an issue because you're going to have children. You're making yourself quite financially vulnerable. You have to often give up your career. You're going to make those choices differently if you're living in a hut in a forest or if you're living in a mansion.
Well, I'm agreeing with you.
I do think that you do need to. The problem often with marriage is that when you have children, all the goalposts change, and really I think the most important thing about the divorce process is to protect the children. It's not about which person gets which and how much money they may or may not have lost if they'd stayed separately. It's about making sure there's provision for the children. So I would be very concerned if getting married meant that you just kept everything you went in with completely. But on the other side, as a mother of three children, I would be concerned about getting married now in case it all goes wrong, and then my children have only got half a house. It's a very confusing, scary area, and I think it might even be putting some people off getting married.
We've spent half an hour talking about divorce, and marriage comes up just at the very end, so I think we'll have to leave that for another discussion. But Gavin Scott, if you could make one recommendation, what would it be?
Well, I can see that there's a number of issues that the Commission have raised, and this is not an easy task. There's so many ideas, so many ways to look at this, and they're all in the report. There's probably more too. And this is going to take some years to implement. So I like to see the ideas that are put forward about needs. I like the fact that they're looking to clarify the principles. But it's going to be a lot of work into it. And I'm going to look forward to seeing what progress they make with that. And bear in mind that the times are changing all the time. The situation with all of us, how we live, how perceptions are always changing, and so a few years down the line I expect that there will be some other ideas come forward and principles put forward. I'd like to see them.
Jeremy, finally from you, if there was just one, which would be the first you'd choose to recommend?
There's so much divorce. My recommendation that we should consider making marriage more difficult and making divorce more difficult to enter into.
I'd like to thank all my guests for joining me to discuss divorce and the new proposals set out by the Law Commission for England and Wales. Jeremy Levison, founder of the International Academy of Matrimonial Lawyers, Levison Meltzer Pigott. Gavin Scott, solicitor at Stowe Family Law LLP. And on the telephone, Tony Roe, principal from Tony Roe Solicitors. And finally, Suzy Miller, a divorce planner and inventor of Divorce in a Box.